For criminal cases, I'd worked in the U.S. Attorney General's office, and also had worked in the prosecutor's office, and I've probably done well over 1,000 criminal cases of one sort or another. One of the things that you want to do in a criminal case is you want to get what the Commonwealth or what the state has for evidence. You don't have to prove anything in those cases, and you want to see what they have, even if you disagree with it, because the Commonwealth or the state's the one that has to prove the case beyond a reasonable doubt, which means to a moral certainty. Basically, what I would do is file a notice of appearance saying that I'm representing you, and then basically get a copy of the police report, the criminal complaint, and any other evidence that I could immediately get from the DA's office. Then I would go over all that evidence with you and get your take on what happened. Then what the next stage would be is to go in generally for something called a pretrial conference date or an arraignment date. And what we want to figure out is what other materials we need to get, if any. We'd also want to see, is this something that we want to resolve? Is this something that we want to go to trial with? Is this something that we want to get things excluded? And getting things excluded is by doing things called like a motion to suppress statements or motion to suppress the stop, things of that nature, saying that the police didn't do what they needed to do, that there were some constitutional issues, and being able to get some of the evidence excluded prior to having it set for trial. Another aspect is you can do something called a motion to dismiss, and if we feel that there's not enough evidence to even show that it's more likely than not that this occurred, you can do a motion to dismiss, which is a very, very effective technique to get a lot of weaker cases out. In addition, you can try and make the Commonwealth show that they have all their I's dotted and T's crossed, and a lot of the time you can get charges reduced or thrown out because the Commonwealth which is the one that has the burden to prove, you're again presumed to be innocent, is that they're the ones that are going to have to show that they're up to snuff on everything and they're able to really prove the case. If you want to resolve the case and the Commonwealth looks like they have enough evidence to be able to prove it, you still don't want to just resolve it on a plea bargain immediately. You want to look at what impact a plea bargain might have on your case, on what it might have on your future, your job, for school, things of that nature. You also want to figure out what type of risk you would have by going to trial, and if it would be a lot higher or lower. Some cases like OUI or drunk driving cases, you do end up wanting to go to trial more often because they have something called a mandatory minimum sentence, which generally is not going to be a lot worse after trial than it is on a plea. Other cases, you're able to do things where you can get pretrial probation or dismissal upon court cost or community service. You also are able to do things where you get something called a continuation without a finding, which is not a guilty finding or a conviction. So if you apply for jobs, it would not be that, but it is an admission to sufficient facts, and you are admitting to it and you'd be on probation with it. Then they're anywhere from the guilty, from pleading guilty with just a file, to getting guilty in probation or guilty in restitution or fines, to getting a guilty in a suspended sentence. A suspended sentence basically means that instead of going to jail, they will suspend the sentence for a period of time, and if you stay out of trouble for that period of time, it will end up resolving. But if you get in trouble, you will have to do that sentence. So you could get, for example, guilty 60 days house of correction, suspended for 2 years. What that would basically mean is that you'd be pleading guilty, that you would have to go to jail for 60 days, but instead of actually going to jail, it would be suspended for the 2 years. You do everything you need to do on probation and don't get recharged with another offense, then it ends. But if you did get charged with another offense, you'd have to have the sentence. The continuation without a finding, on the other hand, is something, again, that you'd have a probation period of time, but the idea is that you stay out of trouble for that year and do what you need to do for that year, it would be dismissed at the end of the year. It would still show up on your record, and particularly as a first offense OUI, it would be considered a second offense. But if somebody's asked you, have you ever been convicted of a crime, you can legitimately answer no on pretty much any application, things of that nature.